The Australian Constitution is encased in the Commonwealth of Australia Constitution Act, which was enacted by the Parliament of the United Kingdom on the 9th of July, 1900. That Act consists of a preamble and 9 clauses. Clauses 3 and 4 are now spent. Clause 7 no longer has any practical application, and Clause 8 is redundant. The Australian Constitution is contained at Clause 9 of the Act. The Constitution of the Commonwealth of Australia is divided into 8 chapters and a schedule. The chapters are: the Parliament, the Executive Government, the Judicature, Finance and Trade, the States, New States, Miscellaneous, and Alteration of the Constitution. Chapter 1 of the Constitution, which deals with the Parliament of the Commonwealth, is divided into 5 parts. The 5 parts are: General, the Senate, the House of Representatives, both Houses of Parliament, and the powers of the Parliament. The legislative power of the Commonwealth is vested in the Federal Parliament, which consists of the Queen of Australia, the Senate, and the House of Representatives. Governor-General, appointed by the Queen, on the advice of the Prime Minister, is the Queen's representative. Other provisions include the salary of the Governor-General, sessions of the Parliament, and the prorogation and dissolution of the Parliament.
Thank you, Mr. President. Supplementary question. Considering that tax does go on quarries, has the government conducted any modelling on the impacts in its great big new tax that it will have on the building costs and in particular on the costs of housing?
I've indicated already on numerous occasions in this chamber, and I'm only too happy to help Senator Williams yet again, the government has commissioned KPMG Ecotech to undertake independent modelling of the tax reform.
The Senate is composed of senators from each state, directly chosen by the people of the state, voting until the Parliament otherwise provides as one electorate. Senators are chosen for a term of 6 years. The number of senators for each state was increased from 10 to 12 by the Representation Act 1983. Section 122 of the Constitution empowers the Parliament to make laws for the representation of territories in either House of Parliament to the extent and on terms which it thinks fit. Both the Northern Territory and the ACT have been allocated 2 senators, making a total of 76 senators. Senators for each state are divided into 2 classes to meet the rotation requirement, so that only half the Senate is elected at each election. Following a dissolution, the entire Senate is elected. Questions arising in the Senate are determined by a majority of votes. The President shall in all cases be entitled to a vote, and when the votes are equal, the question shall pass in the negative.
The Prime Minister to his statement that climate change is the greatest moral challenge of our time. Does he still believe that? Further, does the Prime Minister still believe that to defer action would be, and I quote, absolute political cowardice and an absolute failure of leadership?
Prime Minister has the call.
Thanks very much, Mr Speaker. As I said in response to the question from the Leader of the Opposition before, on both the matters that he raised, neither my position or that of the government has changed.
The House of Representatives is composed of members directly chosen by the people of the Commonwealth, and the number of members shall be, as nearly as practicable, twice the number of senators. The number of members chosen in the several states shall be in proportion to the respective numbers of their people, and shall be determined in accordance with Section 24 of the Constitution. Subject to the Constitution, the Parliament may make laws for increasing or diminishing the number of members of the House of Representatives. Questions arising in the House of Representatives shall be determined by a majority of votes other than that of the Speaker. The Speaker shall not vote unless the numbers are equal, and then the Speaker shall have a casting vote. Other provisions, including the issuing of writs for a general election, the qualification of members, absence of the Speaker, and the resignation of members. This part deals with the rights of electors of states and ensures that a person who acquires a right to vote at state elections shall not be prevented by any law of the Commonwealth from voting at elections of either House of the Parliament of the Commonwealth. Senators and members of the House of Representatives are required to subscribe an oath or affirmation of allegiance as prescribed in the schedule before taking their seat in the Parliament. Section 43 disallows a member of either House of Parliament of being chosen or of sitting as a member of the other House, while Section 44 deals with the disqualification of members in respect of allegiance to a foreign power, treason or conviction leading to imprisonment for 1 year or longer, and bankruptcy. Other sections of this part cover vacancies on disqualification, penalties, disputed elections, allowances, privileges, and rules and orders. Section 51 details the legislative powers of the Parliament to make laws for the peace, order and good government of the Commonwealth, and covers, amongst other things, trade and commerce, taxation, naval and military defence of the Commonwealth, quarantine, census, currency, naturalisation and aliens and marriage. Exclusive powers of the Parliament are covered in Section 52, while Section 53 details powers of the Houses in respect of legislation. A Appropriation bills, tax bills and the recommendation of money votes are covered in sections 54 through 56, while disagreement between the houses is covered in section 57. Sections 58 through 60 deal with the assenting of laws. The Queen may disallow any law within 1 year from the Governor-General's assent. Government House, set in 53 hectares of gardens, lawns and parkland at Yarralumna, has been the official residence of the Governor-General in Canberra since 1927, when the Commonwealth Parliament moved from Melbourne to the national capital. Previously, the Governor-General resided at Government House, Melbourne. It is here that the Governor-General meets with the Queen's ministers in Executive Council, invests recipients of Australian honours and awards, receives visiting heads of state, other dignitaries and the credentials of High Commissioners and Ambassadors to Australia, and entertains many Australians from all walks of life. The Queen of Australia stays at Government House when she visits Canberra. The executive power of the Commonwealth is vested in the Queen and is exercisable by the Governor-General as the Queen's representative. Additionally, a Federal Executive Council advises the Governor-General in the government of the Commonwealth. Members of the Executive Council are chosen and summoned by the Governor-General and sworn as Executive Councillors and hold office during the Governor-General's pleasure. They are known as the Queen's Ministers of State for the Commonwealth. Provisions of the Constitution referring to the Governor-General in Council means the Governor-General acting with the advice of the Federal Executive Council. No Minister of State can hold office for a longer period than 3 months, unless he or she becomes a Senator or a member of the House of Representatives. The Command-in-Chief of the Naval and Military Forces of the Commonwealth is vested in the Governor-General as the Queen's representative. The High Court building is one of Australia's national buildings and also one of Canberra's major tourist attractions. It's situated on 3.4 hectares of land in the Parliamentary Triangle on the shores of Lake Burley-Griffin, between the National Science and Technology Centre and the National Gallery of Australia. The federal government approved the transfer of the High Court to Canberra in 1968. The Court's principal registry had been located in Sydney since 1973, and for 45 years prior to that it had been in Melbourne. The foundation plaque to commemorate the commencement of construction was unveiled by the Prime Minister, Mr. Gough Whitlam, in September 1975. The building was completed in April 1980 and was officially opened by Her Majesty Queen Elizabeth II, the Queen of Australia, on the 26th of May 1980. The judicial power of the Commonwealth is vested in a federal Supreme Court, which is called the High Court of Australia. The High Court consists of a Chief Justice and so many other justices, not less than 2, as the Parliament prescribes. The appointment of a Justice of the High Court shall be for a term expiring upon his or her attaining the age of 70 years, and a person shall not be appointed as a Justice of the High Court if he or she has attained that age. The High Court shall have jurisdiction, with such exceptions and subject to the regulations as the Parliament prescribes, to hear and determine appeals from all judgments, decrees, orders and sentences as outlined in Section 73. The trial on indictment of any offence against any law of the Commonwealth shall be by jury. Many of the provisions dealt with in this chapter are either spent or are no longer used. Other provisions were transitional so as to implement the federation process. The Commonwealth Parliament has exclusive power to impose duties of customs and excise and to grant bounties on the production or export of goods. Section 92 of the Constitution ensures that trade, commerce and intercourse is absolutely free between the states. All revenues or monies raised or received by the executive government form one consolidated revenue fund and are appropriated in the manner and subject to the charges and liabilities imposed by the Constitution. No money can be drawn from the Treasury of the Commonwealth except under appropriation made by law. Section 96 provides for financial assistance to the states. The Commonwealth shall not, by any law or regulation of trade, commerce or revenue, give preference to one state or any part thereof over another state or any part thereof. Chapter 5 deals with the many aspects of state matters, including the very important Section 106, which, subject to the Commonwealth Constitution, saves each state constitution until altered in accordance with the requirement of the Constitution of each state. Section 109 provides for any state law that is inconsistent with a Commonwealth law, ensures that the Commonwealth law will prevail and that the state law will be invalid. Under Section 111, a state may surrender part of its territory to the Commonwealth. This section was used to separate the Northern Territory from South Australia and the Australian Capital Territory from New South Wales on the 1st of January 1911. States cannot raise military forces without the consent of the Commonwealth Parliament. Section 115 prevents a state from coining money and effectively makes the Commonwealth's concurrent power in Section 51(12) exclusive. Other matters include the rights of residents in states and the protection of states by the Commonwealth from invasion, and on the application of executive government of the state against domestic violence. The Commonwealth Parliament has the power to admit to the Commonwealth or establish new states. In doing so, the Parliament may impose such terms or conditions including the representation in either House of Parliament as it thinks fit. The Parliament may also make laws for the government of any territory surrendered by any state, or of any territory placed by the Queen under the authority of and accepted by the Commonwealth, or otherwise acquired by the Commonwealth. The Parliament may also allow for the representation of such territory in either House of the Parliament to the extent and on the terms which it thinks fit. The Parliament of the Commonwealth may, with the consent of the Parliament of a state, and with the approval of the majority of the electors of the state voting upon the question, increase, diminish, or otherwise alter the limits of the state. A new state may be formed by separation of territory from a state, but only with the consent of the Parliament thereof, and a new state may be formed by the union of two or more states or parts of states, but only with the consent of the Parliament of the states affected. Chapter 7 originally contained sections 125 through 127. Section 127 was repealed in 1967. Section 125 deals with the seat of government of the Commonwealth and required that the territory be located in New South Wales and be no less than 100 miles from Sydney. The Commonwealth Parliament sat in Melbourne until it moved to the new territory, now the Australian Capital Territory, in 1927. It has been suggested that the wording of Section 125 ensures that the ACT remain a territory and could not become a state under Section 121 of the Constitution. Section 126 gives the Queen the power to authorise the Governor-General to appoint deputies. The letters patent relating to the office of Governor-General should be read in conjunction with this section. Section 127, which read, "In reckoning the numbers of the people of the Commonwealth, or of a state or other part of the Commonwealth, Aboriginal natives shall not be counted," was repealed by the Constitution Alteration Aboriginal 1967 referendum. Section 128 is the only section in Chapter 8. Although it is the last section in the Constitution, it is probably the most important, as it outlines the method by which the Constitution may be changed. Once a law to amend the Constitution has been passed by both houses, it is then put to the electors in each state and territory qualified to vote for the election of the House of Representatives. However, it is possible for a bill to change the Constitution to be passed by only one of the houses as outlined in paragraph 3 of section 128. If in a majority of states, a majority of the electors voting approve the proposed law, and if a majority of all the electors voting also approve the proposed law, it is then presented to the Governor-General for the Queen's assent. Additionally, other aspects relating to the states, For example, representation in either House of Parliament or the altering of the limits of a state as detailed in the penultimate paragraph of Section 128 may require that a majority of the electors voting in that state also approve the proposed law. Senators and members of the House of Representatives are required to make and subscribe either an oath of allegiance or an oath of affirmation in accordance with Section 42 of the Constitution before they can take their seat in Parliament. The oath is: I, A.B., do swear that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law. So help me God. The affirmation is: I, A.B., do solemnly and sincerely affirm and declare that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law. The name of the King or Queen of the United Kingdom of Great Britain and Northern Ireland for the time being is to be substituted from time to time. This schedule does not apply to the swearing in of executive councillors as required by Section 62 of the Constitution.